Evening and welcome to PM Ghana here on Adwar Television. This month we've been having conversation with the National Labour Commission. So far as the Labour Month is concerned, we've been looking into details of what goes into the Labour Act. We're looking at some of the mandates that the Labour Commission is having. And today we are having conversations on complaints and how to file complaints to as well. This is an opportunity where whether you're an employer or an employee, you need to stick and stay with the conversation to understand that whilst the internal modalities are done in your organization, like Fatima made mention of last week, Thursday, that when there's an issue, there's first of all has to be an internal resolution processes. When that is done and then still if there's no resolve, then you can then move to the commission. But in moving to the commission, what are then modalities that you need to go through to ensure that at the end of the day, you are doing what is right, what is required of you, as a complainant, be it be an employer or an employee. So this evening, the conversation is going to be purely on the compliance or complaint filing processes and what needs to go into it as far as the National Labour Act is concerned, or the National Labour Commission is also work mandated, is also has to do. So we're going to go that quick. So when we come back, my fine guest is here, and then we're going to find out what she has to tell us as far as the complaint processes of the National Labour Commission is all about. To stay tuned, we'll be right back. Come back from the tender. My name is Pepsival. We're streaming live on Facebook, Adwar Television Ghana, not on YouTube, Adwar TV_GH. And like I indicated before the turn, complaints filing processes with the National Labour Commission. I have the Assistant Public Relations Officer of the Commission here with me, Miss Julia Paulvi. How are you doing, madam?
I'm good. How about you?
I'm good. How was your weekend?
It was okay.
Tell me about it.
It was good.
Chill and cool, eh?
Very cool.
All right. Anyway, my was also church. You know, I'm a church boy, so I like doing church stuff. So
I hope you prayed for me as well.
I did. So far, because I've been seeing you going up and down here and there doing your work, so I need to pray for you for energy and life.
That was why my weekend was full of grace.
You are graceful as Gracie. Anyway, welcome to the show tonight.
Thank you.
Sure. Now is everybody at the commission too?
Oh, they're doing well.
Interesting. I hope Madam enjoyed her time the last time you were with her when she was here.
Yes, she did.
Awesome. Anyway, so let's kickstart our conversation. First off, one of the mandates that the Labour Act gives to the Labour Commission is the resolution of disputes between employers and employee. So, by your work, what types of disputes or the nature of disputes does the Commission addresses?
Okay, so basically the National Labour Commission is established to handle labor-related disputes such as unfair termination, unfair labor practices, refusal to negotiate, violation of union rights, non-payment of salaries and benefits, redundancy issue, among others, including maternity protection, among others. Now, when you look at the powers of the Commission, Section 139 says of the Labour Act 2003, Access 51 says that the Commission shall exercise the following powers: receive complaints from workers, trade union, and employers or employers' organization on industrial disagreements and allegations of infringement of any requirement of this Act and regulations made under this Act. That is what the law says.
So the law gives that authority to the Commission to be receiving complaints, one, from employers.
Yes.
Workers, And then employees themselves.
Yes,
Okay. Trade unions among other
employers
things.
organizations.
So you've enumerated. It can be concerning termination, it can be concerning maternity, it can be so any other form of, so far as the the employer employee.
Yeah.
Let me stick to this one.
Yes.
The employee employer relation is concerned.
Yeah.
If that brings the relationship a rift, they can come to the commission. I think that it was established through you that every organization needs to have an internal resolution mechanism. So it is that is exhausted before it comes to you.
Yes.
Now, when it comes to you, how is it done? Do you take it verbal, or there is a form that somebody has to take and fill, or you just have to someone just pick or send an email to you that, hey, hello, this is me, my name is Pepsival, I work at Adwar Television, they failed to pay me for the last 3 months, and then I'm bringing it to your attention. Is that what the mechanism is?
So when there is an issue and then you follow the internal processes and then you haven't had any resolution to the matter, you formally lodge a complaint, and it has to be done in writing. When you look at regulation, the National Labour Commission Regulation 2006, popularly known as the LI 1822, it says that complaint to be in writing. And Regulation 6 says that the complainant shall submit a written complaint to the Commission or complete Form A, complaint forms, specified in the schedule to the regulation and submit it to the Commission. Now, when you look at this regulation 2006, when it was first brought to bear, a sample of the complaint form was provided.
Attached to it.
But since then, the commission, the complaint form has undergone a number of reviews, and today this is what we have as the complaint form that we use at the commission.
Okay, so that's all you have on the screen.
Yes.
All right.
So if you have any labor disputes and you call the office or even send a mail, we will direct you to download the form, fill. That is, if you're not at the office premise at the commission, we would ask you to go on our website to download the form, fill it and submit. However, if you come in person, we'll give you a copy of this complaint form to go and fill and then submit it after you are done filling it. So that is what happens.
So this is a form.
Yes, this is
what entails on the form? I'll come back to other modalities as far as this form is concerned, but what does the form entail? Because I can see maybe definitely there has to be a date, but give me the details. What are the components of the complaint form as far as the Labour Commission is concerned?
Yes, before you lodge a complaint, there is supposed to be a complainant and then a respondent. A complainant is someone who comes to lodge a complaint, and the complaint form is a formal document that one uses to lodge or formally lodge a complaint at the commission. So when you pick this complaint form, there are some requirements that we need, which is one. If you look at number 1, it says details of the complainant or complainants in dispute. That it should draw your attention to the fact that there can be one complainant or a number of them. So number 1 is a status of the complainant or complainant. So you can be an employee or an ex-employee. Even if you are an ex-employee, you will still take employee. Yes. So we have an option of employee, an employer, a trade union, or an employers organization.
Okay, so
that means that whether you are a worker or an employer or a trade union, you can be a complainant.
Okay. Now, I just want to put examples into these things. I am a teacher. I have a problem with the government of Ghana. So I am coming in as an employee, isn't it?
Yes.
But if it is through the Ghana Educational, if it is through the Graduate Teachers Association, NAGRAT, TEU, or any other thing, they've qualified to be a trade union.
Yes.
All right. If my employer, that is the Ghana Education Service, is having a problem with me, then it comes under
an
employer. If the Ghana Education Service, the Ministry of Education, and then the Ministry of Finance together have an issue with me, the employer, can he then qualify to be employers organization?
So usually employers organization is represented by the Ghana Employers Association. So the employers that are under their membership when they have an issue maybe with the worker, they can lodge a complaint through the Ghana Employers Association, and they become the employers organization.
Okay.
Yes.
Okay. So there's a whole body in Ghana that all employers are part of.
Yes.
Okay, so people that give work, be part of this organization. Yes. Oh, interesting. That's awesome. All right, so you can continue with the 1B.
Okay. So, and then we have an option that another portion that is 1B that says name of complainant. If name of at least one leader if complainants are many. I earlier stated that a complainant can be one or individual or more. So if it's one individual, let's take you for example, you are lodging a complaint against Adwa TV at the commission. You provide us with all your details at 1B, that is your full name, your postal address, telephone, WhatsApp, email as well. These are forms of communication or channel of communication we can reach you through.
Okay.
So when you lodge a complaint and maybe we need some information from you, we can either call you or send you a WhatsApp message or email to easily reach you for any further information. And if you are more than one, if you are two, it will be your full name and the other person's full name. So let's take you Pepsival, if you are two, it will be Pepsival and then Kwame.
Okay. And Selassie, my producer.
Yeah. Yes, and Selassie, your producer. But however, since your name starts, you are the lead complainant. So you provide us with all your details at number 1B, and then the number 1C, which is alternative details of the complainant. Selassie will be the alternative contact. So he will provide us with all his details over there.
Okay.
Now, when you are more than two, it will still be you, your full name, however, and two others, meaning you are three.
That's three.
If you are five, your full name and four others, meaning you are five. And one of the others will provide their details as the alternative contact details.
Okay. So that is 1B. I write my name Pepsival and two others.
Yes.
Pepsival and four others.
Yes. If you are
okay. If you are many, if it's just me, I solo.
Yes.
I write my name in capital letters, Pepsival. But if it's me, Udate, Mary J, Lester, that is three of them. So I write Pepsival and other three.
Yes.
Or three others.
Yes.
And then they one that is 1C. That is one of them.
Yes.
We have to provide their full name.
Yes.
And then their details over there.
Yes.
Why is this so? Is that maybe you will be calling me and then I will dodge? I don't want to come and then you call them.
Yes. So when you lodge a complaint, we also need to have easy access to you. However, we know sometimes there can be challenges. So in an event whereby it's difficult to reach you, we can call the alternative contact to reach you or either deliver an information to you through your alternative contact information.
All right. Point 2.
Then when you look at point 2 says details of the respondent party with whom you are in dispute with.
So maybe me have to provide that person.
Yes, you
need
to provide
as a complainant.
The details of that person. We do not know the person. You are the one bringing somebody as a respondent, so you need to provide us with that detail. And as I indicated earlier, whether a worker, an employer, a trade union, or employers organization, you can be either a complainant or the respondent, give or take. So if the worker is lodging a complaint against the company, then the company would become the respondent. And in this case, you will take employer. Then you provide us with the name of the company, title of the head, be it managing director, chief executive officer, executive secretary, the director, chief director, whatever the head of the institution's position is, you provide us with that person's position. And then where it says name, if not a company. Now, respondents are not all respondents are own companies. Some are individuals. Let's take domestic workers, for example, or domestic work, for example. They are employed by individuals. So in this case, it's not a company. So when it comes to number 2 like this, and you are a domestic worker or you are directly employed by an individual to do work for them, you wouldn't fill the name of the company. You leave it blank since the person is a person, not a company. You don't provide any title of the head because it's not a company. You just go straight to name, if not company. Provide us with the individual's name, their postal address, GPS address, and location, so that we can easily locate the person. The reason being that we also need to serve the respondent. We need to be able to find the person or the institution and serve them. So you need to give us accurate location to the place. We don't want to over struggle to find the place, or we go there severally, we don't get the place. If we don't find the respondent, your case may be at the commission for long because we are unable to serve them properly.
Okay, I'll come to you on this one. But Neil, let's Gamanche, let's move to the next. Okay, good one there. I wanted to find out if we would have to provide the telephone numbers or emails of the respondents.
Yes.
That is, I wanted to find out before this one. So as what I said, we are going to provide telephone numbers, email, fax, and cell.
Yes.
So I find okay, so the telephone number can be, it's not mobile phone number. What's the difference between cell and then telephone?
Some use landlines.
Landlines. Oh, okay. So the landline will go to what? Cell.
Telephone.
And
Yes.
then the
Cell will be the normal
bam,
that
bam,
we
bam.
have.
Come on, let's go back. Kelvin, good one there. Now let's for purpose of clarity, let's expand this one for instance. Like we are going through the form, and then we've established that in the case that I am the complainant, so I am the complainant. So I failed the 1A, and then 1C has been catered for. So the 2, this is the respondent. So I'm going to take my employer.
Yeah.
Then the name of my company, Adwa Media Consult. Then head of the title of the is director. Now at the name, you see putting if not a company. I've already written the company's name. Do I have to write my director's name there?
You can just leave it blank.
I can leave it blank.
Yes.
But if I want to do proper case, I can write Regina and send you there.
We would erase it because it's for companies.
It's for company.
Sorry, that portion is just for an individual.
An individual.
If the person is not the respondent is not a company but an individual, that is where you start feeling from. But since the head of the institution is working in the name of the company, you don't need to add a person's name.
Okay. So that means every liability is ascribed to the organization,
yes.
but not the individual, because they are holding forth in the name of the organization.
Very well.
Bam. Julia, you make in fact you make clarity. Let's move. Let's take.
Yes, so we also have a portion whereby you give us the telephone number of the company, the cell number of the company as well, if they have it, fax, WhatsApp, or even email. So you provide us with this information so that when, in case maybe we are serving them a letter, we can even call them to let them know that, okay, so and so has lodged a complaint at the National Labour Commission and we are coming to serve them. So how can we find them? Maybe they can give us direction to the location for us to serve them. Also, sometimes with the physical location, some of the complainants will say that, the head of the institution mostly is not around, so it's best that we serve them through mail. That way, when you draw our attention, we monitor on it that, okay, this person can easily be reached through email. So whatever information we want to serve, we should serve it through the email or fax or WhatsApp number or fax, whichever would be will make it easy to reach the respondent.
To reach the person.
So that is why these options are there.
Okay, all right, that's wonderful. In fact, trade here it's my problem, meaning that a lot of things can come up. But like, let's go. So tell us the type of disputes that you would want. So that's based on these things you take them.
Yes. So depending on what your
3.
issue is. In fact, before we even give you a complaint form, we normally ask you your purpose for coming.
Okay.
Then you narrate the issue. When you narrate the issue, then we get an understanding of what the issue is. But then we ask you, because you have to tell us what do you think the issue is. So let's take it, for example, your employment was terminated. You will narrate everything and we would ask you, so what do you think about it? If you say it's unfair, then this is the option you take, unfair termination.
Unfair termination, okay.
Because maybe you believe that the termination was not mutual, you weren't given proper notice and all of that. So based on that, you may take unfair termination because as you've indicated, maybe you were not given notice or proper notice. The termination was not done mutually and you are aggrieved about it. Now, we also have an option of unfair labor practice. Maybe certain things are ongoing that you feel is unfair. You are expected to meet some deadlines, but you're not given the tools for work, which is unfair labor practice, or you are being discriminated against. It also falls under unfair labor practice. Now, we also have refusal or failure to negotiate. Sometimes the union would represent the workers at negotiation based on salaries, allowances, and whatnot. And then it's time for negotiations, but the employer has refused or doesn't want to go into negotiations with the union. So they lodge a complaint on refusal or failure to negotiate, and then the commission would invite parties to come and find out why, and either direct parties to go into negotiations. Then we also have violation of union rights. Sometimes, because you're a member of a union, then the employer may bring a policy whereby non-unionized members have certain benefits, which is unfair to you, a union member. So based on that, you also take violation of union rights. Then we have non-payment of salaries and benefits. Sometimes you would work, the employer would refuse to pay you what is due you, and you can lodge a complaint based on that the employer owes you salaries or a salary or some benefits that you want to take from the employer. We have SNIT contributions, which, as you are aware, SNIT is mandatory, but some employers may not pay. And due to that, you would have to lodge a complaint on it that the employer has refused to pay SNIT contribution, which is very important to you, the worker, because when you go on retirement, that is what you survive on. So we also determine SNIT issues, such cases as well. Then we have violation of terms and conditions of employment. You are employed, you sign a contract of employment. It has listed some things that ought to be done between both parties, that is the employer and then the employee. However, assuming you are employed and your salary is supposed to be like 3,000 a month, but after you started the job, then the employer starts paying you 2,000. You have violated or varied the terms of agreement, because you agreed on 3,000 a month as your salary, not 2,000. So why is he paying you 2,000? You have every right to lodge a complaint with the National Labour Commission, and you take that option as well. We have redundancy pay. Sometimes maybe the company is undergoing certain major changes in the institution, and therefore your unit or department has become redundant, and they have declared it. You've negotiated, you've agreed on something to be paid as the redundancy pay, or there is a formula for calculating redundancy in the institution, but then after everything, the employer has refused to give you that redundancy pay for you to go and sort yourself out. So you can also lodge a complaint on that. Then we have skills development and training. If you remember, we talked about protection of employment, where we talked about the fact that the worker has the right to be trained.
Exactly.
I entered into the commission with a BA in public relations, and I'm a public relations officer. But when you enter into any organization, the organization has its own mechanisms. At the Labour Commission, we are an adjudicating body, so I need to understand even what adjudication is, industrial relations is, the labor law, and all of that. I need to be trained or retrained in such to be able to deliver effectively on my job. But if I enter I work there, you don't train me, yet you have certain expectations of me to come here and sit and talk about labor-related issues when I haven't been trained, is an unfair labor practice as well. So I have every right to complain that no, you expect me to go on air to talk about industrial relations, labor-related issues. I haven't been trained. I want to be trained on those things so that I can properly deliver. Yes.
What you are expected to do.
Then we also have implementation of collective agreements. Sometimes you hear of strike cases, and when you go into the substance of the matter, you realize that it is failure on the part of the employer to implement the collective agreement, or what was agreed on the collective agreement. So you hear unions going on strike because of the non-implementation.
But the recent one between TU and then the rest people.
Yes, so it's a similar thing. Then we have disclosure of information. I give my information to the employer, and which is supposed to be private. If the employer even wants to share my information with a third party, they must
with your consent.
My consent, which they haven't done. So I have every right to take them up at the commission. We also have freedom of association. Workers of Adra TV want to unionize, but the Adra TV says they would allow you unionize. You have every right to lodge a complaint against Adra TV for refusal to allow you join or form a union. So that is why the option is there. And we have maternity protection that protects the women workers of the workforce, or female workers, or pregnant female workers in the workforces. So the maternity protection is there to protect their rights, as I mentioned. So you get pregnant, you've given birth, you ought to go on maternity leave, 12 weeks. Then the employer says no, you have every right to lodge a complaint on it. Or after the 12 weeks, even the physician has certified that you have to take another 2 weeks to rest because your delivery was through C-section, the employer has refused to grant it, you have every right to lodge a complaint on it. Or the fact that you went on maternity leave or even got pregnant and then they've terminated your contract because you've gotten pregnant. We've seen an example of such. I think the lady worked with a church school, and then she got pregnant and her contract was terminated because she got pregnant.
Wow.
And not just because she got pregnant, but got pregnant out of wedlock. So because of that,
You say it's a church school.
Yes,
It's certainly not Anglican. I know it's not Anglican. Go
and
ahead,
she was terminated because of that. So with this option, she will take maternity protection. Then we have dismissal. Usually dismissals are based on grievous offenses or major offenses that you might have committed within the institution. So if they gave you a dismissal letter, you can lodge a complaint on it so that the commission will go into the matter and find out if indeed the issue is truly a dismissal or not, so we can determine it. Then we have workplace injury medical claims. So with this option, you got hurt on the job. If you get hurt on the job, the employer is supposed to take care of you, your medical expenses and whatnot. But then here's the case whereby you got injured on the premise of the organization, and then you've gone to the hospital, but the employer has refused to take care of you or pay the medical bills. You have every right to lodge a complaint against them. And we have others, please specify. Some may feel that maybe whatever their labor-related issue is not part of these options provided, so they may want to tell us what they believe the issue is. So we have that option of others to specify what exactly you believe your issue may be or your labor-related issue may be.
Yes. Well, I have a concern for us. Probably if it's maybe it is a sexual assault.
Yes.
Because it's not specified here.
It's not specified, but then we have an option that says please specify
so
what it is.
It could be that.
Yes, you can write sexual harassment at that portion as well. Yeah.
My producer is saying in my ears that what if somebody is sacked on the basis of work romance, love at work, for having a boyfriend or girlfriend at a workplace? It's not also specified. So
you specify what it is you believe the labor dispute is.
Okay. Now, on the issue of violation of terms and conditions of employment, I have an hypothetical case where maybe I expected, is the labor ask you are supposed to work 8 hours in a day, and then I am told that I work 8 hours, so that is what the terms is being. Then I come, or maybe in the course of the work, there is a directive that, okay, we'll be working, let's say, from 6 o'clock a.m., no, from 8 o'clock a.m. to 6:30 p.m. at night, almost like 7. Then I realized that it is more than the 8 hours duration in a day. But I know that because it's coming from my authorities, even if I should make a complaint internally, I will not get any better resolve. It finds itself clearly variation of the terms of conditions of employment. Can I still go ahead and then come and then make a formal complaint?
Yes, you can go ahead to make a formal complaint, but you must still start internally.
Okay.
You just don't speculate that because it's coming from your employer, even if you go to them, they will not provide any solution to it. No, you must still start internally. You discuss it with them. Yes, you've seen this new directive. This is what the law is saying. Can you reach an agreement with them so that you negotiate something? And as you're aware, we have overtime in the law. So if after 8 hours, the other hours will be considered as overtime, then you look at it from the point of view of it being overtime, which means there should be payment for overtime. And if there is payment of overtime, how much are you looking at per hour? Or what formula are you going to use to calculate the overtime period? These things need to be discussed between yourself and the employer before you even come to the commission. It helps your case because if you started internally and you're making your case, you have evidence to show that yes, this was a new directive that was brought before at the ADWA TV, and these are the processes that you have also embarked on to find redress. However, upon all these processes that you follow to have this matter resolved, it hasn't been resolved,
Still
and
stalemate.
therefore you are coming to the commission. It supports your case, it adds value to your case when you start with the internal mechanisms before coming to the commission.
Interesting. I think I mean, the evidences and starting up, it's what would you be the attachment you conclude you add up to for, because it's a brief facts of the dispute you are referring, and then it says that you should be able to attach copies of relevant documents, be it appointment letter, termination letter, dismissal letter, collective agreement, and etc. So even if you're going through some internal processes, whatever the result is to, expected to attach to this one.
Yes.
Good.
So when you look at number four says brief facts of the dispute you're referring to. Now, we usually call a petition, which is a formal letter. You address it to the Executive Secretary of the National Labour Commission. And in that letter, what's the format we normally want, or the template that we use, is that you begin with an introduction of yourself. We need to know who is lodging the complaint.
I am Pepsival, broadcast journalist of Adwa Media Consult, was
Yes.
employed in the year 2009.
Yes.
Okay.
You narrate everything, who you are, where you work or worked, when you started working, how long you've been working there, what your position is or was, and then narrate the issue, what you think about the situation or the issue, and what you want the commission to do for you, all in that letter. Now, this space there is so small, so it has to be typed on the computer and printed out and attached to the complaint form as a petition. So you attach it there, and then, as you indicated earlier, attach all copies of relevant documents. So first of all, after attaching the petition, we want you to first of all start by establishing employment relationship. That is, if you have any documentation to show. So it could be your appointment letter, contract of employment, or whatever documents you have to show, or employment agreement, some call it terms of conditions or conditions of service. You will attach whatever document it is to the complaint form. If the issue is termination, you will attach your termination letter as well. If the issue is dismissal, you will attach your dismissal letter as well. If it's if you are talking about some clauses in a collective agreement, you have to attach a copy of the collective agreement for us to know which portion of the collective agreement was contravened, and what perhaps maybe you are seeking a relief that is also within the collective agreement. Which portion are you referring to, so that we can see and be guided by all of these documents. So that is why it's important to attach those documents. That is not to say that if you don't have these documents, you cannot lodge a complaint. You can still lodge a complaint whether you have the documents or not. But it's better that if you have the documents, you must attach it.
True. You made mention of the fact that this is more of like the part of the meat of the complaint.
Yes.
This is where you are putting your petition. You are filing the full complaint in terms of details.
Yes.
But I see the lines there not to be enough. And you made mention of the fact that it starts with the format of introduction, among other things. Does it mean that number 4 of the complaint form can be exerted on a different sheet?
Yes,
you can type it on a different sheet.
Yes, that is why I said it should be an attachment.
Okay,
You type it on a computer, print it out, and attach the petition to the complaint form. Because, as I stated earlier, this portion is so small to narrate the whole issue, and we need to know the issue, understand the issue. I'm just not going to say that, oh, my name is Pepsival and my contract was terminated. We must know why.
Details.
If something led to the termination, we must know why, when it started, what it was, why that happened, and why it led to your termination. We must know and understand what it is, everything.
Okay, that's wonderful. Now let's jump to the 5th point. Now they said details of remunerations. Even if the complaint you are making is not on remuneration, does it mean that you still have to state it? That, okay, this is my last salary and other benefits I get. So far as maybe I'm talking about unfair termination, or maybe I'm talking about discrimination, or maybe I'm talking about disclosure of information or maternity protection. Am I still expected to talk on salary?
Yes, the reason being that most of the times, whatever reliefs people seek are monetary. And based on that, we need to know what your last salary or current salary is. The last salary has to do with if you are an ex-employee, but if you are still working within the institution, you provide us with your current salary, because mostly the reliefs, as I mentioned, are monetary, and therefore we need to see what the last salary is and if you have any other benefits. So even when you fill this, you attach a copy of your payslip or bank statement or mobile money statements to support the information.
Awesome. Gamanje, let's move. Kelvin, let's move. All right.
So number 6 says state which relevant documents are attached to the complaint form. That is where you write the titles of the documents you are attaching. That is the offer letter, the contract, the collective agreement, termination letter, dismissal letter, leave. If it's leave and you've already filled the leave form before, you attach all the documents. So you write all the titles at number 6.
At number 6.
And then attach the documents accordingly.
All right. So that can now put the date of the dispute when the problem started.
Okay, yes.
Okay. Not the date you are filing the complaint, but when the dispute actually started. Okay. Yes. All right. Now, number 8 is what?
Number 8 talks about the details of dispute procedure followed.
Have
you followed any or all internal grievance procedures / disciplinary procedures before filing this complaint at the commission?
Yes or no?
So with this number 8, whether yes or no, you explain why. And as we indicated earlier, you must first start with internal processes before coming to the commission. If you lodge your complaint and then we find out that there were internal processes that you haven't followed, the commission may ask you to go and start with those processes first before coming. The commission usually is supposed to be your last stop, not your first point. Yes. So we would want to know the processes that were followed. If there are internal grievance procedures within the company, let us know the processes that were followed. And if it was a disciplinary action like termination or dismissal, what processes were followed. That way, when we see any code of collective agreement or code of conduct or HR manual, we can deduce whether indeed the company erred in following its own procedures or not. And that may help your case, whether you would win your case or lose your case. So you must provide us with such information as well.
Interesting.
So if you were terminated, for example, it might have begun with a verbal warning, then led to a written warning, then maybe a query which you would have responded. So you write there, you started with a verb, the employer gave you a verbal warning, then a written warning, you were given a query, you responded to the query, you were given an invitation letter before a disciplinary committee, you went for the disciplinary committee, they made these findings, you were given the recommendation. However, you just state everything there briefly, and then we see the process that was followed internally.
Then come to relief that you're seeking. Maybe you want your salary to be increased.
Yes.
You want certain things to be done for you.
Yes.
You want your employer to be arrested with immediate effect. That is just by the way.
Yes. So with the reliefs, as you mentioned, those are the reliefs, and reliefs basically is what you want to gain at the end of the day. So with the reliefs, we always want you to go straight to the point. We don't want long stories over there. Just tell us exactly what you want. Some people, they will come, they want something, you want compensation, or this amount has X amount of compensation. Then you come in and say, oh, I want you to help us resolve it. We don't need that. We want you to tell us exactly what you want. So if you want 10,000, write the 10,000 as compensation for unfair termination, whatever it is you want. If it's monetary, we want to see the monetary value. If it's salary related, you must let us know the date, which is the month and the year you are requesting for. So if it was like, for example, April salary, you write the payment of April 2025 salary into brackets the total amount. We need to know the year and then the total amount involved. So that is how we expect the relief to be. Go straight to the point, no stories over there. Just tell us exactly what you want. Don't be shy.
It's not like if they don't have some, then they can do this one, or they can no. Just go straight to the point. I want 10,000. That's compensation.
Yes.
All right. Now the 10 and 11 is where my concerns are, where it's asking whether the issue has already been decided upon by other adjudicating bodies, or if 11, if there's another, or if this complaint is pending before another adjudicating body. Are there adjudicating bodies beyond the NLC's adjudicating bodies?
Yes.
Are there others?
Yes, there are other. The National Labour Commission is an adjudicating body. We also have Labour Department that deals with some of these labour-related issues, such as the workplace injury. When you get hurt at the premise of the office, the employer ought to go to the report it to the labor department, and then you go to the hospital, you submit your medical report, and they will calculate your workman compensation for you. So if you took the dispute to the labor department and then they already made a determination on the matter, you have to indicate
Specify.
yes or no, and then we would know whether to also hear the case or leave it as it is. And also, mind you, if you take your case to court and you bring it to the commission, we cannot hear it.
Because it's already taken you to the court,
Yes.
taken to the extreme level already.
Yes. So we can't hear it. So if the case was already previously decided by the court, we don't hear it as well. So if you indicate what it is, then we are able to let you know whether we can hear it or not, or whatever decision.
In the event the person choose to hide the fact that the matter has already gone to court.
Well, during the process, it may come up. Maybe the respondent will let the commission know that, oh, this case is already pending before the court, or the court had decided it, and this is evidence to back it. And if we get to know, it would also inform the commission on what decision it should take on the matter.
All right. I think it's the last form, the last bit of it. Yes. Yeah. All right, so let's come to 12. So you still the sector in which you find yourself in. Good one, that's media. So we can take media. You've done well that you've placed us there. Media.
Yes, so we would like to know the industrial sector the complaint is coming from. So we have a number of options over there. If it's a retail or wholesale organization, we want to know. We want you to let us know what it is. If it's private security, let us know. If it's the public or civil service institution, let us know. Health service, printing and paper, mining, transport, general services, chemical, agriculture, whatever it is, let us know the industrial sector you work in. And we also have an option that says specify. So some will tell you that, oh, where they work is not within the options we've provided. So we tell them to specify exactly what it is, the industrial sector they find themselves in, so that we have an idea.
Okay, so in the event of security services, are they the ones that you said for
private security?
We government security services. You don't do for.
We don't. So the Labor Act doesn't cover those that fall within the Intelligence and Security Agency Act. That is the services that we normally call it as. That is the police, the military. We don't deal with them. So if they even come and they lodge complaint, we normally ask them to route it through their mother ministry to address their issue, because it doesn't fall within our jurisdiction. But the normal private security, like the
nightclub bouncers,
probably,
or bodyguards, but private bodyguards,
or from the West Take, among other places, you will take private security.
All right.
And after that, you sign. So the lead complainant or complainant signs at number
13.
And then so you sign the lead complainant, like I said, or if it's an individual complainant, you would sign at number 13. And then for official use would be for us,
the officers at NLC,
to endorse to start the whole dispute procedure.
Interesting. Step by step, 13 points that we are supposed to go through when completing the complainant form. How do we assess this form? Is it at your office or it is available on your website?
This form is available at the office, and you can also download it from our website. So if you have our telephone number and then you call and then you tell us what the issue is, and we realize that it's within our jurisdiction, we would ask you to download the complaint form from the website. It is www.nlcghana.com. You go, you download it, you fill it, and attach all relevant documents that we need. That's if you have them. And then submit it to the nearest office close to the respondent organization or the respondent per se. Normally, when you're lodging a complaint, you need to lodge the complaint close to the respondent, not where you are convenient. It has to be close to the respondent.
I don't get it.
So Adwa TV is here in Accra here. So if you have a labor dispute, you have to lodge it at the head office, head office. That is where we are, the head office is. You cannot take it to Tema because you stay at Tema and you think it's more convenient for you over there. So you take it to our Tema office. No. you have to lodge a complaint at the office closest to the
I
respondent.
mean the NLC's office closer to the respondent.
Organization. Yes, you have to lodge a complaint
Sure.
over there.
So people cannot move from Kumasi and bring their disputes or complaint complete a complaint form to you in Accra if the respondent is resident in Kumasi.
Yes.
Sure.
And even if you do that, sometimes you don't know that the respondent is not within this
The catchment area.
Yes. So even when you lodge a complaint over here, and then maybe the respondent draws our attention to the fact that no, they have an office at Kumasi, we'll refer the case to our Kumasi office, and then the Kumasi office will call parties to come to a hearing at the Kumasi branch. So that is it.
Interesting. Now, do you have specific days? Okay, so when this is done, how does the form get to you? How does the complainant get the complaints to you? Is it by emailing? Because you say you can get it either they call you or via your website you can get. When I'm done completing it, how do I get my attachments and everything to you? Do I come to your office?
So you can come to any of our offices to submit the complaint form, or you can send it through DHL
post office,
post office, or any of these delivery
the post office. Will it come to you?
It would come to
because I don't want the case to tell me that I've complained and you didn't get my complaint. Is it going to come?
It will come. It will come. So it will come if you mail it to us as well.
Sure. Do you have any specific day that we can lodge or
yes,
time in the week?
We only work during working hours or work days, which is from Mondays to Fridays.
Okay.
Between the hours of 8 a.m. and then 5 p.m. If you come after 5 p.m., we may not be able to attend to you. Yes, and if you also come on public holidays, you'll not come and meet anyone there. So you have to come within working hours, 8 to 5 from Mondays to Fridays.
Interesting. 8 to 5 from Mondays to Friday. So you don't come there on Saturday or Sunday.
No.
The 24-hour economy is as not applied to the National Labour Commission. No. For now, it doesn't apply.
Now,
yes. Maybe it's yet to, but for now, that we are talking to you today being the 27th of May 2025, 24-hour economy is yet to. So you go there within structural hours, that is between the hours of 8 a.m. and then 5 p.m. at night. That is from Monday to Friday. And then you can submit your complaints to them as you have completed, including all your attachments that is done. You've indicated that, so we can use the beginning part. Do we type all? Or we can just use pen to complete the other part, with the exception of the move to the second page. Yes, only 4 that you have to type it.
Yes.
The other part, you can just use normal pen to complete it. Okay, that's fine. Is there some specific requirements that we need to know when completing the complainant's form?
Yes, as indicated, if you have documents to support your case, it's very relevant to attach it. If you have documents to show employment relationship as well, you have to attach them. Number 5, I indicated that you need to attach your, let us know what your last salary is and other benefits, which if you have a pay slip or bank statement or mobile money statement, you need to attach it so that we see the evidence of it or the amounts involved.
Does it take long to process the complaint at the commission? How long does it take? Even if it takes long?
So it depends on when you go. With our regional offices, it's they don't have so much pressure on them, so it's
faster.
It's faster. Faster. In no time, they process and then write to the employer to respond to the allegation. However, at the head office, because of how the bulky nature of the cases that we receive, it takes about 3 weeks to a month to process and write to the respondent to respond to the allegation. Now, when we write to the respondent to respond to the allegation, we also give them 14 days to respond to the allegation. That's the first time, which we call request for response, or 14 days. We give them the first letter, and the first letter, we give them 14 days to respond to the allegation. If they don't respond within that period, we have to give them a second letter as well.
Which takes 7 days.
Which will take 7 days. And if they don't respond to it, then you will start with the last dispute resolution process, which we call summary settlement by the commission. Now, we have a number of dispute procedures. The first one is called facilitation, which is done by the commission's industrial relations officers. They facilitate the settlement of dispute. If you look at the functions of the commission, it talks section 138 says to facilitate the settlement of industrial disputes. So depending on whether the respondent responds to the complaint or not will determine whether you will start with our first dispute resolution process or the last dispute resolution process. When they respond, you start with the first dispute resolution process, which is done by the Commission's industrial relations officers. They would invite parties to come and then attempt to help parties reach an amicable settlement. Theirs is not to determine the matter or determine whether anyone is right or wrong, but to help parties reach an agreement, which will be signed by parties and witnessed by the industrial relations officer. However, if they don't respond, the respondent does not respond to our request for responses, then you will start at the last dispute resolution process, which we normally call commissioners hearing. That is handled by the commission. Now we have a 7-member panel commission members, which we call commissioners at the commission or members of the commission. And they are those who have the power to subpoena presence, among other things, as well as to determine the case, whether the respondent is present or not. They can determine the matter they can hold an ex parte hearing and determine the matter as it is. So if the respondent hasn't responded the first time, the second time, it goes to them. If we invite the parties to come and then the respondent fails to come the first time, maybe it will be adjourned to give them time to come again. If we invite them the second time and they don't come, then the commission would hold an ex parte hearing or one-party hearing, listen to the case. Maybe you'll be sworn on oath because the respondent is not there. The complainant will be sworn on oath to give their submissions, their testimony, provide money, provide evidences, among other claims, bring witnesses if need be, and everything will be transcribed and sent back to the respondent to respond to the allegation. If it is sent back to the respondent to respond to the allegation and the respondent still chooses not to respond to the allegation, then the commission will make a ruling or give an award on the dispute.
Interesting. The last bit that is very much important to me is kudi, cash. Do we have to pay if we are filing a complaint?
No, the processes are free at the commission. So picking up a form is free, facilitation is free. However, you remember I said we have a number of dispute resolution processes. As I indicated earlier, the first one is called facilitation. The second is mediation. We have the third one being voluntary arbitration. Then we have the summary settlement and compulsory arbitration. That is done by the members of the commission. Now, when you start with the facilitation, it's free. It's done by the commission's own staff. It's very free. No, you don't need to pay anything at any point. However, mediation and voluntary arbitration is fee paying. The law gives us the right to maintain a database of qualified persons to serve as mediators and arbitrators. And they are not our staff, they are not the commission staff, they are third parties whom we have a database of as qualified mediators and arbitrators. So when you choose the option of mediation and or voluntary arbitration, we give you those the list of the mediators and arbitrators.
The database that you have collected under the act.
Yes, for you to select the person you want as a mediator or arbitrator, and you pay for them.
You pay for their services?
Yeah, you pay for their services.
Is it the complainant or both the complainant and then
both
the
complainant and then the respondent? You divide the amount and pay them accordingly. So the complainant will pay half of it. So it's currently 1,850, which is divided between both parties. So per each sitting, the complainant and respondent are supposed to pay 925 per sitting. That's if you choose the option of mediation or voluntary arbitration. However, if you skip mediation and or voluntary arbitration, then you go for summary settlement. Summary settlement is also free. Very free. So you don't need to pay. You don't pay anything over there.
Well, summary settlement is being done by the staff of the commission.
Yes. So they are not staff of the commission, but then they are appointed. They are the 7-member panel who are appointed by their representatives. So it is sort
of like the commissioners.
Yes. When you look at the composition of the commission, it is made up of 2 representatives from organized labor. We have 2 representatives from the employers' organization.
4.
And 2 people from the government. And it's 6. The employer and then the union that appoints the chairman, making it a 7-member panel. And the president appoints them in that position. So based on that, it's also free as
And
well.
then I understand that some of them have fixed tenure. They have some of them
they
have
have
4
fixed
years.
tenure.
Hmm.
So my executive secretary will say they are part-time workers
Okay.
at the commission.
Okay.
So they are at that level too. Is also free. So people normally skip the mediation and or voluntary arbitration and opt for summary settlement because of the free nature of it over there. And also, whatever award, if you win your case, whatever award that you receive, we don't take anything from it. We don't take a percentage, not even 1% or 0.0001%. We don't take anything. Everything goes to you, the complainant, or you, the one who has won the case.
Interesting.
We don't take anything from you from beginning to end.
So when I even win the case, I'm not supposed to give you brown envelope and say thank you to you or something.
No, we don't have thank yous.
Okay. I do your human's job.
We are doing our job for God and country.
Good one there. Any final outs for the viewers watching Surprise? Because people have said that anytime complaints are filed, they know that at the end of the day you'll be ruling in favor of the employer, and then the employees will never have a case. What assurances are you giving on behalf of the commission that it is liberal, it is open to mediate where the situation is and find out lasting solutions that both parties are going to be happy or be beneficial to both parties?
Okay, so as we were going through the complaint form, you realize that there were options that says employer, employees, trade union, and employees organizations. That is to tell you that the commission is not a human rights institution. We are an adjudicating body. So anybody can be a complainant, be it if you're a worker, a trade union, an employers organization, or an employer. So everybody can come to the commission to lodge a complaint. Now, lodging a complaint doesn't mean you have a case. That is one thing people think, because you've lodged a complaint, it means you have a case, or they feel that because they've lodged a complaint, it means they'll win the case. No, you are lodging the complaint for redress, and the commission will help you determine the matter. So if you have a case, at the end of the day, you will win your case. If you don't have a case, at the end of the day, you will lose it. However, that is why at facilitation, we normally encourage parties to reach an amicable settlement whereby we both agree to it, whereby it becomes a win-win situation. Because if you have entrenched positions, it's about looking at the interest of the matter, not the entrenched positions. You don't need to have entrenched positions when you are trying to reach a resolution to a dispute. You have to be more liberal, open-minded, negotiate. Don't come and say, oh, if you are overdoing, I know my rights, I know my rights. It is at the point of I know my rights that will determine the matter. And if you win, they give the commission a good name. If you lose, they give the commission a bad name. So at facilitation, we always hope that parties will agree on something, not to have entrenched positions, but agree, and then it becomes a win-win situation. And like I stated earlier, lodging a complaint or being a complainant doesn't mean you automatically win your case. You may lose it as well. So we normally, when people are picking forms, we normally advise them to be open-minded, and we educate them that picking a form doesn't guarantee your success. Nor does it mean that you're going to fail or lose the case. No. We are there to adjudicate the matter, and however it ends, you accept it as it is.
All right. Thank you, Ms. Julia, for your time. Before you go, I have a quick birthday to do, and then we call it a night. Today happens to be the birthday of Miss Antoinette Na Aku Alote of the Cathedral Church of the Most Holy Trinity, where she is the AYPA secretary. She is the AYPA secretary. So on my own behalf, she's my sweetheart. Let me say a very big happy birthday to Miss Antoinette Naku Alote. But the birthday I've been joined by your Alote families, where Leicester is part of them, and then your cathedral people like Udate, Nat Bongo, and then Mary, your AYPA vice president. Accordingly, have all joined in the felicitations, and then they did too as well. Your former AYPA president have all joined in the birthday wishes to you. So on our own behalf, we are saying a warm happy birthday to you, Antoinette. Keep soaring higher, keep looking beautiful, and I'm glad that you are the tallest human being I've come across. Keep being tall, fine, sweet, dashing, and dazzling too as well. Happy birthday one more time, Antoinette. Hi, Miss Julia. Thanks for the conversation with regards to your folks back there, and then see you when I see you. Today you don't have any birthday. Eh? There's no birthday you have to do.
No.
All right, so that is the Assistant Public Relations Officer at the National Labour Commission. She is Miss Julia Pawovi, very wonderful woman who has been spearheading together with Totime, the media engagement of the National Labour Commission. A very big thank you goes to you, and then Totime and the rest of the team at the commission. I'll see you when I see you. Have a good evening, and then see you next week. Or maybe on Thursday, maybe. Maybe. All right, so that is a maybe. Yeah. Thanks for being part of tonight's edition of PM Ghana. My name is Pepsival. God bless our homeland Ghana and make our nation great and strong. Have a good night. I'm out.
Osa very mamo